due to, and
So that schedule change has been approved? Or
yes, the group has,
Yes.
we opened up a window for voting, and overwhelmingly the vote was for that schedule change.
So
Again,
that
that will
will
not take
start.
place until the week of September 15th.
Heard. Thank you.
So that's when we will switch. It gives people some time to change their schedules. Lastly, City Manager Jones alluded to this. The next CIG meeting is when we will begin discussing peaceful protests. We had a lag at our last meeting related to the Civil Service Board presentation, and so to allot them more time to get together their presentation for this meeting, we will move the peaceful protest piece till the next CIG meeting, which will occur next week, Thursday. And so, in conclusion, that is our update.
Thank you, sir. Do we have any questions yet for Mr. Rios? Again, noting that some of what we're going to be talking about later, he will get us up to speed on the feedback from the community input group as it relates to the topics that they covered in the last meeting when we get to those for our discussion. Not seeing any hands as of yet, so let's jump into policy stuff. Chief, if you will let us know what the latest is on our seeking to better align with the 8 Can't Wait initiative.
Yeah, thank you, Mr. Chair. So we shared last week where we were with the 8 Can't Wait and the progress that very proud of that we've made to this point. And if you can remember, last week we spoke of 4 that we were still working with the architects of the 8 Can't Wait, and those were duty to intervene, ban shooting at moving vehicles, require exhaust of all alternatives before shooting, and require comprehensive reporting. So our policy team and the 8 Can't Wait folks that we've been continued to work together, and we've met standards to reporting the requirement with the body-worn camera, tagging and reporting, as well as the signal sidearm that I spoke of last week. That has been able to meet the requirement for comprehensive reporting according to the 8 Can't Wait cohort, people that have, architects that have worked on that. And we've also met the duty to intervene standard that we spoke with, that it falls under our neglect of duty policy and rule of conduct. Some of the things that we continue to work on, there are 2 locations that we need to still come together and meet with and talk about and hopefully satisfy at some point. The one that I'm least optimistic is the restriction of shooting at moving vehicles. We've still been working on the idea of whether a vehicle can be used as a deadly force weapon towards individual or individuals. And we've seen across the nation where vehicles have been used as weapons to run into protests or groups of people, and some of those, the only way to stop that individual was to fire at the moving vehicle. And so we're working with the architects of They Can't Wait on that as well, to try and hopefully come to a resolution and have some sort of some better dialogue that can satisfy that requirement. The other one is the requirement of exhaust all alternatives before shooting. I feel very confident in that. They're requesting a specific statement that states that deadly force is only to be used as a last resort. I think a lot of our wording indicates that already, and we're going to be working on that to make sure we satisfy that that piece of the 8 Can't Wait as well. So that's my report on that, if there's any questions.
Can you reiterate with the holster monitors?
Yes.
The implementation of that, those have been rolled out. What percentage of the force have those been rolled out to now, and will they ultimately be every single patrol officer?
They are actually rolled out to every patrol officer at this time. So we got our first batch in, and that was enough to satisfy for every patrol officer. And the goal is to continue issuing those out to every sworn officer with a firearm.
And then are there members of our department that are not necessarily on kind of normal patrol that don't have those, or should anybody with a CMPD badge, should the public expect that they would have that technology as part of their turnout gear?
At this point, there are folks that, like our CMPD detectives, some of our specialized assignments, but at this point, there are some that do not, but that's just a matter of logistics that we need to get those others ordered and in, and then we can equip the officers with it. But what we wanted to do initially, because of the amount of contact with our patrol that they have with the general public, that was the first phase that we wanted to make sure we got that rolled out.
So all patrol have it, and ultimately all sworn officers will.
That's correct. Now, there may be some exceptions with undercover
Right.
officers, things like that, but yes, the goal is to equip all officers with it.
Thank you. Ms. Watlington, you had a question?
Real quick, I just wanted to know very briefly, in regards to the shooting at moving vehicles, I saw on the 8 Can't Wait matrix that there were some cities that already had it. Can you talk a little bit about what their policies state?
Yeah, what I can tell you is we have always had a policy against shooting at moving vehicles, but we also had an exception in if that vehicle is used as a deadly weapon by a suspect, to where if it was trying to run over an officer and that officer had no avenue of escape, or if we had an event where the vehicle ran into a crowd and we had no other means to stop it. What the discussion with the 8 Can't Wait folks is that they feel that a weapon, their opinion is that a vehicle cannot be used as a deadly weapon. And of course, we are contrary to that belief and thought that we feel like there needs to be an open avenue to where we can't just say that we can never shoot at a moving vehicle. And that's really the hang up with them. And at one point we were, go ahead.
I'm sorry, I might not have asked my question. I was actually asking about the benchmark cities, what their policies reflect right now, because I would imagine they have the same concerns as CMPD. So I was curious as to what ultimately ended up in their policy, or if there were any comments regarding the benchmark cities.
How have the cities that have complied per Campaign Zero's analysis with that item written their policies? Is that the question, Ms. Watlington?
Yes, that's the question. Thank you.
I certainly can get that for you and make sure, but my understanding is there are some agencies that have come out and said there will be no shooting at moving vehicles. So I can get some more information on that and provide that at a later time.
Okay, thank you.
All right, I don't see any other hands, but I am glad that we are not only making demonstrable progress towards that goal that we set as unanimously as a council, I guess that's been 2 months ago now, but that we are still working with them and not just giving up on the ones that are a little bit harder. So, Chief, as I stated 2 weeks ago, and I think was echoed by at least one of our community input group members, but I'm sure the sentiment is shared across the committee, I think it was a powerful statement on your part, and one that I'm greatly appreciative of, that you said, you know, yes, we had put out this graphic that said CMPD had something in their policy that addressed all 8 of these. While that might have been true, I think we as a council and a lot in the community felt like that just because we had something didn't mean we had the right thing, and that we were really as far as we needed to be on some of those items. And I think that the work you've done since has shown that there was room for improvement, and your willingness to admit that we had a room for improvement, take down that graphic and say we're not going to put that back up so we feel like everyone's on the same page, was a demonstration of your willingness as chief to be a part of this work with our community, and for that I'm greatly appreciative. If we don't have any other questions, we are, I don't want to jinx us, but we're moving along well here. Mr. Jones.
So, Mr. Chair, I was going to say the same thing. So through the first 3, great timing. I just wanted to make sure that members of the committee, and we'll make sure that we have this out to the community. There were 8 questions asked last time, and the staff has provided answers, I believe, to 7 of the 8, and they ranged from the types of calls that police receive, all the way to police pay comparative to other jurisdictions. So I just wanted to
And
let
if
you know.
anybody at home wants to pull that up as reference, you should have an email from 10:29 this morning. Thank you to Gwen Miller for getting that out to us prior to our meeting. So if you haven't seen that, look for Gwen Miller's email from 10:29, and that will give you a lot of the data that many of you have asked for over the course of the last couple of meetings. And I do have Ms. Ajmera with a question. Ms. Ajmera?
Thank you, Mr. Chairman. So for the rules of conduct intervention, 11.B, what has changed there? I didn't follow that one.
Is as related to 8 can't wait, or is this something that when we get to agenda item 6?
No, it's still part of the 8 can't wait. I guess it's still, I guess why it still says manifest it. Okay, is there still a manifest injustice threshold? If Chief can explain that.
What I can tell you, Councilwoman, is that the our duty to intervene that falls under neglect of duty was enough to satisfy the 8 can't wait. We did have to make some minor adjustments to the wording on that, and we broke it out as duty to intervene in the comments that go along with it. But I will have some discussion on that with the rules of conduct presentation as well, but we were able to satisfy that with the 8 can't wait architects.
Okay, so the request that we have gotten for specifically this rule is that there has to be a change of language where it would say, it will say what the request came from. I'm sorry, I'm trying to sort of juggle here in between two screens because, I'm looking at my iPad, but at the same time, there was this request that came from 8 Can't Wait organization. So when you look at rules of conduct, I can wait till let me get this specific language for you, and then I'll just wait.
But
Okay.
I think what she's saying is that the Campaign Zero, the organization that created 8 Can't Wait, took a look at what CMPD's revised policy is and said that that met the threshold for what their expectation or their recommended policies.
Yeah, and if I may, Mr. Chair, just also the website is a couple of weeks behind, so so if you're looking at it now, it might say we only satisfied 3 or 4 of the recommendations, but they are a couple of weeks behind on updating it, so that will be updated soon.
I think that will help because certainly there is a gap between what's been presented to us versus what's on the website. But if I will review the website once it's updated. If I have any questions, I'll reach out to you, Chief. Thank you so much for your leadership.
Thank you.
I would imagine that there are a lot of cities probably that are doing what we're doing, which is trying to get more aligned as many of these issues have been brought to the forefront publicly. I'm guessing we weren't the only city that had citizens calling for better alignment with those type of policies, and Campaign Zero probably finds themselves right busy these days trying to have the meetings they've been having with police departments all across the country, keep their website up to date. And we do appreciate them lending their time, Sam from Campaign Zero, to speak to our community input group recently, which I know was very valuable to that discussion. All right, so if we are clear there, then we will move to our city clerk, Ms. Kelly, to discuss the roles of the Civil Service Board and Citizens Review Board.
Good morning, Mr. Chair, Vice Chair, Manager, Attorney, and coworkers. I'm going to just provide a brief overview of the Citizens Review Board and the Civil Service Board. You've heard this before. I think Ms. Jameson provided an overview, but this is a very brief overview. Next slide, please. The Citizens Review Board was established in 1997, and the board reviews appeals by citizens who file complaints on dispositions imposed by the chief of police or his designee relating to allegations of misconduct against a sworn police officer. Currently, the board is comprised of 11 members. 3 are appointed by the mayor, 5 by council, and 3 by the city manager. And you can see the breakdown of the membership. The most current member was appointed a couple weeks ago, so that demographic is not reflected in the numbers shown there in the breakdown. The types of complaints that the Citizens Review Board reviews there are 5: the use of force, unbecoming conduct, arrest, search and seizure, arbitrary profiling, and discharge of a firearm by an officer which results in the death or injury of a person. In addition, the board also serves in an advisory role to the chief of police, the city manager, and the city council. And it is charged with making periodic reports to the chief of police, the city manager, the city council, and the community relations committee. And the board also provides an annual report of their activities. Going back to the membership of the board, the terms of office are 3 years staggered, and each member is, in accordance with city policy, is allowed to serve 2 terms. Serving as counsel to the board are 3 attorneys from the firm of Robinson and Henshaw, and they are Carrie Davis, Julian Wright, and Gabe Wright. So that's the Citizens Review Board. And if Wendy would go to the next slide, I will just speak briefly about the Civil Service Board.
Madam Clerk, if I can real quick jump in and allow the Vice Chair to ask a question there.
Thank you, Mr. Chairman.
Sure.
And Stephanie, this might be a question actually for council and the city manager and the city attorney. Why do we set up to have outside counsel to staff this board as opposed to internal attorneys?
I don't think it's fair that Patrick put his mask on just now.
I want it muffled so no one hears what I say.
There are pros and cons, as I've talked to Patrick about this in the past, and I think Patrick will tell you about the pros and cons.
Yeah. So I think it was baked into the legislation, and I'll have to double check that, of how the board would be staffed. Not every community has outside counsel doing it, and I came from a community that did not. The city attorney's office handled it in Durham, and in Charlotte it's always been this way. And I think it's baked in to the enabling legislation, but I'll double check that.
And Mr. Chair, just follow. And Julie, no offense to you, but I'm just asking the question because I cannot remember when I got on council that we had outside counselors. So I think it's just a question. So,
and if I could add to that, I mean, the issue, the pros and cons are, I know in Durham on occasion, when a complaint wouldn't go forward.
If anybody who's on the call that's not muted, if you can mute, we're getting a lot of feedback from somebody.
Yeah, the pros and cons relate to the role of the attorney, and the attorney's role was very limited. But if a complaint didn't go forward to a full hearing, there was some pushback as to, well, you've got the city attorney who's defending the city in the room. It's not a surprise that it didn't go forward. And the other side of it is the cost associated with hiring outside counsel. If you can properly limit the city attorney's role, then you're not incurring those costs, nor do you have the city attorney, with that perception. But the reality is the perception is the perception, if people feel that way.
thank you, Mr. Chair. Thank you, City Attorney.
Mr. Mitchell, this is Julian Wright. I assure you, no offense taken.
Okay.
I think the original decision back in 1997 to hire our firm had to do both with the reality and the perception that you didn't want potentially members of the city attorney's office representing both the the police department, and representing the board that was making those decisions.
Okay.
That to promote the independence of the board to the citizens who would be filing appeals with it, it would be important for it not to be an attorney in the city's attorney's office providing advice to the decision-making body.
Got it. Thank you.
Makes sense. Ms. Kelly?
Distinction between one distinction between the two boards, the Civil Service
Excuse me,
Board.
Kelly, this is Matt Newton, and I'm sorry, Mr. Chair, I had a question as well, and my hand went up a little late.
Oh, sure, go ahead.
So I apologize. Before we move on, I just had a quick question about the Citizens Review Board. I wanted to ask, and I don't know who could field this, but do we know what assistance is provided to citizens to navigate the process that was described, whereby they file a complaint or address or raise a concern, and then to get in front of the board and thereafter? Do we have assistance for those folks? What is that?
Mr. Newton, currently the Community Relations Committee has a staff person that is dedicated to assist citizens in the process, to assist them in completing the form, submitting the form, and the appeal form is also available in several different languages, so that the Community Relations Committee is available to assist people without walk them through the process.
I think Chief Jennings wanted to speak to that as well.
Yes, thank you, Mr. Chair. So also, when a citizen does have a complaint that is reviewable by the Citizens Review Board, we are obligated to give them the results of that complaint, and at that time, we do provide them with information on if they would like to appeal it to the Citizens Review Board. We give them that information to get them started as well.
Chief, this is at the conclusion of so it's my understanding this is at the conclusion of an internal affairs investigation. Is that right?
That's correct. At the conclusion of the investigation, they get that opportunity.
So everybody who's eligible to potentially appeal or pursue that investigation to the Citizens Review Board gets a packet of information letting them know how to do that, is what you're saying?
That's correct.
Okay. And thereafter, oh, sorry? So thereafter...
Is that Mr. Wright? Mr. Wright, did you want to speak to that?
No, I'm sorry. I'm sorry. I'm on the phone. This is Kerry Davis. I'm Julian's law partner at Robinson Bradshaw, and I thought I might just add something to Councilman Newton's. I just wanted to let you know, Matt, that the Mecklenburg County Bar has got a group of folks, a panel of maybe 15 lawyers who have volunteered on a pro bono basis to assist in these cases if a citizen asks for it and qualifies for pro bono legal assistance. Right before COVID, a couple of us had organized a CLE to do about an hour's worth of training on handling CRB cases, and then COVID came along and we haven't had any new cases on the CRB since, but there is certainly an initiative that is ongoing in the Mecklenburg County Bar to train up folks on a voluntary basis to assist as counsel on pro bono counsel to citizen complainants.
Mr. Kerry, I really appreciate you weighing in and knowing really the crux of my question, because I think you've answered it fabulously. I can only imagine how confusing and potentially intimidating the process can be from start to end. And I think it's great that on the front end we're providing the information, but also throughout the entire tenure of the process, doing all that we can, even if it means that we're partnering with attorneys on the private side through pro bono services. Doing all we can to help folks through this process throughout its entire tenure, all the way to the conclusion. It sounds like that's what you're saying here with attorneys that are are on that private side available to help even after that initial beginning of filing the complaint with the CRB. So thank you so much for that information.
Of course.
Great. All right, Ms. Kelly, back to you.
Thank you, Mr. Chair. Going on to the Civil Service Board, which is a quasi-judicial board that was established in 1929. It is different than the Citizens Review Board, and quite honestly, people often confuse the two, but they are two distinct advisory boards. The Civil Service Board, as I said, was established in 1929 as an act of the General Assembly, North Carolina, a General Assembly. Currently, there are 9 members, 3 appointed by the mayor, 6 by council, and you can see the breakdown of the membership. They too serve 3-year terms, staggered. They meet the first Tuesday of each month. Meetings are open to the public, and they, before COVID, met at the Government Center. And their monthly meetings generally last about an hour, sometimes a little more than that, and then they conduct hearings. And the counsel to the board is a member of the city attorney's staff, and it's Andrea Leslie Fight is the attorney for the Civil Service Board. The Civil Service Board exists currently to primarily evaluate and potentially approve applicants for employment submitted by the police department and by the fire department. Both departments do a thorough background of each applicant, provide that information to the board members. They they take a lot of time in advance of the meeting to carefully review the content of the application. And it's about a 13-page or more application that is required for each applicant. So they review those applicants and, as I said, potentially will approve them. And also, they are charged with approving promotions provided by both departments. And also, one other thing that the Civil Service Board does is that they conduct disciplinary hearings for each of the 2 departments, police and fire. When either one of the chiefs cites someone for termination, that requires, that's an automatic disciplinary hearing. The hearing panel is made up of 5 members of the Civil Service Board. Hearings can last anywhere from 1 to 3 days. I would note that the Civil Service Board, in conducting these hearings, they have subpoena power, and they also, in accordance with the legislation associated with the Civil Service Board, those disciplinary hearings can be open to the public or closed, and it's at the discretion of the employee. So they hold these hearings, and at the end of the hearings, they make a decision whether to uphold the leader chief's recommendation to terminate or to reinstate an employee. They also conduct hearings for employees that may have received disciplinary action such as a suspension, and that requires a 3-member panel, and they then will conduct the hearing and make a decision as to whether or not to uphold the chief's recommendation in those cases. The last thing I would add about the Civil Service Board is that according to the charter, they have the ability to request an investigation from the police or the fire department of police officers or firefighters that are in the public's interest. And notably, the Civil Service Board has, for the first time in my 16 years, almost 17 years working with them, requested an investigation by the police department of the incident of June the 2nd of this year, and is awaiting the findings of that investigation. So with that, I would just be willing to answer any questions. Also, I think on the line is the chair, Mr. McGill. He may be available to answer questions as well.
And I actually believe that Ms. Jamison, who's the chair of the Citizens Review Board, and
Oh,
Mr.
yes, I
McGill,
forgot
who's the
about-
chair of the Civil Service Board, are going to give us a quick presentation from their viewpoint as well. I've got Ms. Watlington's hand up. Ms. Watlington, do you want to ask a question of Ms. Kelly, or do you want to get the presentations from our chairs first?
We can get the presentation from the chairs first.
Great. Ms. Jamison, if you will lead us off.
Tanya, do you want me to take this?
Yeah, so the way we're going to do it is Carrie's going to give you all an overview, not the basics of it, but basically the policy recommendations that we have proposed in the past, those that have been implemented, those have been sort of partially implemented, and then talk you through a little bit about the policy recommendations that we have moving forward. So, Carrie?
Super. Thank you, Tanya. And good morning, everybody. I'm sorry I'm doing this by phone. I had a devil of a time trying to get in by WebEx and eventually couldn't, and our agenda item came up, so here I am on the phone. But if you'll indulge me, I'll try to move through this quickly. And the CRB, on behalf of the CRB, we certainly appreciate the opportunity to talk about the work, the important work that the Citizens Review Board has done over the years. I think, most folks understand the CRB to exist, primarily, if not exclusively, to hear citizens' appeals when they are dissatisfied with the results of an internal affairs investigation and determination by the chief not to punish an officer for something that is alleged to be a violation of the 5 policies that Stephanie highlighted. And I think there's been plenty of press about that the CRB oftentimes sides with the police department and the understanding of the role as just being hearing these cases. But I want to focus, the CRB wants to focus on perhaps a lesser known function, and that is the role that Stephanie mentioned of serving as an advisor to the chief. And specifically with respect to the council's current project of reviewing CMPD policies, we wanted to sort of highlight the important work that the board has done over the years to make policy recommendations. And so you understand, the board, as a matter of statute, gets access to confidential personnel information. So what that means is they get the complete internal affairs record, and outside of the police department, they're the only folks who get to see that kind of stuff. So they're in a really unique position to evaluate, on a really granular level, the facts of each case. And they are the sort of eyes of the public to say, hey, maybe we can do things better. And so in the context of nearly almost 100 cases, we've had, 94 cases now, there have been dozens of recommendations that the CRB has made to CMPD over the years in connection with these specific cases. So they'll hear a case, they might determine that CMPD didn't err in not disciplining an officer or not finding a violation of policy, but in looking at the application of that policy to specific facts, comes up with a recommendation that, things can be done better. Maybe the policy needs tweaking. Maybe we need a new policy to address this kind of thing. And so that's what we want to focus on today. And I'm going to talk about 3 different things. I'm going to talk about, just give you an overview of policy recommendations that have been made by the CRB that CMPD has adopted. Then I'm going to slide into a second category. Those are recommendations the board has made but have not been fully adopted. And finally, the board just wants to highlight 3 specific policies for emphasis as we go through this process of taking a look at policies, whether that means strengthening the power and authority of the Citizens Review Board, or maybe a policy that would benefit the community and CMPD. So with that, Stephanie, can everybody see this document it's got the header overview of CRB recommendations and opportunities?
Yep. We've got it right in front of us.
Yes, it is, Carrie.
Super. Sorry, I haven't even asked that. So, okay. Well, let me slide through those and start with the de-escalation requirement. The Citizens Review Board has been making recommendations related to de-escalation and wanting to see specific de-escalation language in CMPD's use of force policy, now called response to resistance policy, and has been making those kinds of recommendations since at least the Keith Scott matter. Eventually, CMPD has put de-escalation language in the policy. It's candidly not as strong as what the board advocated for, but it's in there now, and it's part of it. There's a bigger focus on training on de-escalation, and so we view that, the board views that as sort of a feather in its hat, something it's been pushing for years. Second is body-worn cameras, and that has been an iterative process over the years, and I mean, stretching back more than a decade. And from the board standpoint, there was always a desire for objective evidence. I mean, in a lot of cases, when you didn't have, as you can imagine, a camera or something recording what folks were saying, you would get to a hearing in front of the Citizens Review Board, and you would have a citizen saying, X happened to me, and the police officer says, no, Y happened, and the Citizens Review Board is left with X and Y. Who are we supposed to believe? And is it, an abuse of the chief's discretion when that was the standard back in the old days, or now was it error for the chief to side with his own officer versus a citizen? Really hard to make that call. So, in a number of cases, the Citizens Review Board, it sure would be nice to have video and audio so that we can look objectively, and it's not a he said, she said situation, but we can tell what happened. And so there was a push for that over the years, and as we now know, body-worn cameras are universal, but the Citizens Review Board was always behind the push to get that done. There are some specific cases, there are specific contexts in which the body-worn cameras have got to now be activated, and one is when you are asking a citizen when you don't have a warrant and the law enforcement officer wants to search a resident, and you have to get consent from the resident. Requirement now that the body-worn camera be activated. This arose out of a fatal shooting at North Lake Mall on Christmas Eve 5 or 6 years ago. Off-duty officers who are in uniform are also required to now wear body-worn cameras even when they're working off-duty. The third item to highlight here, there are now time limits in place when officers need to complete investigations of minor traffic incidences. The fourth, there is a requirement that the DMVR be activated when transporting a suspect in the police cruiser to the jail. There was a case involving allegedly some inappropriate language and an officer, sort of saying some sexually suggestive things to a female suspect in the back, and no audio to confirm, who was telling the truth. And so now there's a requirement that be activated. The duty to intervene. That is something that CMPD initially pushed for. The Chief Putney asked for citizen input into the use of force policy, and the Citizens Review Board said, well, we think there ought to be a duty to intervene. This was before George Floyd, and that was not adopted. In the recent high-profile Franklin appeal, that was something that was part of the CRB's recommendations as well. Please add a duty to intervene to the policy. And then George Floyd happened, and now it is part of the policy. But the Citizens Review Board has been out front on that issue, for at least a year now. The final one that I'll just call everyone's attention to is a new vehicle apprehension policy in the wake of Keith Scott. Folks will recall that Mr. Scott was in a parked car in an apartment complex parking lot and was spotted with there was a weapon in his car and a marijuana cigarette, a joint, and so there was a decision made to surround the car, and an officer used his baton and breached a window, and then we know what happened after that. There is now a new policy in place about vehicle apprehension in the wake of Keith Scott. So those are all examples of recommendations made by the CRB after hearing and sitting for, in the case of Franklin and the case of Scott, sitting through not only initial hearings but also the evidentiary hearings that can stretch for several days, and taking a good, hard, deep dive look at these cases and making recommendations and adopted. So the board feels really proud and good about the work that it's done in the way of recommendations, and it's had a cooperative relationship with CMPD. CMPD listens and, as these examples show, implement policy recommendations. The second category I want to cover are ones that have not been fully adopted. And so I'll start with subpoena power. This is one that folks talk about a whole bunch, and there's been a push by the legislative delegation to get this through the legislature in Raleigh. That has not been successful. For a number of years, CMPD was behind this, and then recently in the Franklin case, this was the first time in 94 cases that an officer who was the subject of a complaint did not show up at the evidentiary hearing. And in one of the recommendations that the CRB made at the conclusion of the Franklin case was, we think that officers ought to be required to show up when they're the subject of a CRB case and show up to the hearing. And when I think that was when it sort of was pushed into the spotlight, that subpoena power can also be used to require the attendance of CMPD officers who are the subject of a complaint. And CMPD said, that's a bridge too far. We're not going to require officers or we're not going to be behind a subpoena that would require the attendance of an officer at a hearing. And so we've had some good discussions with CMPD, though, with Chief Jennings and with Manager Jones, and understand now that CMPD is behind subpoena power as a universal subpoena power. That would be for both, officers and third-party citizens who are witnesses in a particular case. We don't know what the prospects, how long that might take to, depending on what happens in November, but whether subpoena power will ever be given to the Citizens Review Board in Charlotte. I'm sure that there are other cities that have review boards that would also want that, and so. Until then, one thing that the Citizens Review Board has been kicking around is, could there be, as a matter of city policy, a requirement that CMPD officers who are the subject of a CRB appeal case be required to attend? Frankly, that is something that the police department is not in favor of, and I know Chief Jennings is on this call, and he'll correct me if I get this wrong, but the thinking being that there ought not be a requirement as a matter of employment policy to require an employee, a CMPD officer, to attend when nobody can compel, without subpoena power, can't compel a citizen off the street who may have relevant evidence in a case to voluntarily show up, or you can't compel them to do that. So not fair to require officers if you can't also require citizens to attend. And so that's where we are. I will tell you, I'll sort of give you a flash forward, but one of the things that we would ask everybody to reconsider is until subpoena power is given and granted to the CRB so that they can compel witnesses' attendance, that at least requiring an officer to attend, that's a little bit more information or more evidence for the CRB to consider in making its determination. And there's certainly, in the CRB's view, can't be any harm in having more evidence in the record. Now, if it is an officer who is the subject of a complaint, the officer obviously doesn't leave his or her constitutional rights at the door. And if it is a question that's appropriate to take the Fifth Amendment in response to, the officer, of course, retains the right to plead the Fifth in response to a question. So we're not saying they're required to answer every question. Of course, they can refuse to answer and assert their Fifth Amendment rights. Next is this is something new that has not really been talked about, but the CRB has asked CMPD to consider a new classification or a new disposition in shooting cases. So the way it is right now, a shooting is either justified or it's not justified. And a shooting is justified if the shooting meets an objective standard that is laid out in the U.S. Supreme Court case called Graham v. Connor. And that standard is whether or not the officer reasonably believed that his or her life or others' lives are in imminent threat based on the totality of the circumstances. And in most cases, that standard is dispositive. It is an officer-friendly standard. It's one where if the suspect has a weapon, that it is hard for folks to conclude that the chief gets it wrong when it says that the officer is not, reasonably believes that he or she or others around are in imminent danger, depending on how the weapon might be held or whatever. But it is an officer-friendly standard that has resulted in typically officers being cleared, including in some cases when there are some, perhaps bad judgment calls, other things that officers have done to escalate a situation. And so, the frustration is that all these shooting cases would come in front of the Citizens Review Board. The Citizens Review Board would say, gosh, we either have to choose justified or unjustified. And there were a lot of things that led up to this shooting that if somebody had just taken it easy and tried to take some time and some space and distance, de-escalate the situation, perhaps not violate, some other policy, that it sure is frustrating that the board has got to find this as a justified shooting, and it didn't feel right because there were some things that led up to it that things could have gone in a better direction had other choices been made. And so there was a case, and it was a fatal shooting out on Albemarle Road about 5 years ago, and it was an undercover officer driving an unmarked car, no lights or anything, and a suspect hits this undercover car, fender bender, and then flees. And the undercover officer pursues. This is like 3 o'clock in the afternoon, Albemarle Road, busy, and sort of chase. And they eventually end at a stoplight, and the suspect, who the officer is chasing, gets out of the car with a weapon drawn. The officer gets out, draws his weapon. There's a shootout, and the suspect ends up dead. But the officer, there's a CMPD policy that requires lights to be activated when you're pursuing, and this was an unmarked car, undercover officer. From the suspect's point of view, the reason for that policy is from the suspect's standpoint, he doesn't know if it's an officer or if it's a road rage situation, somebody just giving chase because they're mad about a fender bender. And so it was out of that case that the Citizens Review Board said, how about a middle ground finding of justified but potentially preventable? Those kinds of cases where you see maybe at the moment of shooting that Graham v. Connor standard that I mentioned was satisfied, objectively reasonable to be an imminent fear, but there were some bad judgment calls made that escalated the situation that led up to the shooting, maybe a policy violation that's relevant that escalated the situation. So we have advocated for that. I'll talk a little bit more about that in just a second. But that's one that the board feels is important. That says number 4. It really is number 3. Study reaction time when a suspect has a gun, but the gun is the gun is pointed at the police, but the police officer has his or her gun trained on the suspect. The suspect has a weapon down at his or her side. This was the Keith Scott case, and there's just a question whether or not do you have time, if you're the officer with your gun already trained on the suspect, do you have time to wait to see what the suspect is going to do with that gun that's down at his or her side? Or are you justified in believing that weapon could be used to fire and that you wouldn't have time to react, so you can go ahead and be justified in discharging your weapon? If folks remember the facts in the Keith Scott case, that was the fact setup. And there was an attempt by CMPD to design a study that would test that, and there were just some difficult things because I think that the actors in the study had to know something was going on, and maybe it was very difficult to control for a test that folks could feel confident in the results. But that one has not been completed. And finally, the duty to intervene, and that has now been incorporated into CMPD policy. And the only thing that we would flag here, and I'll just give a preview for, and we'll take care of this one, is the duty to intervene resides under the neglect of duty directive. And as Stephanie mentioned a while ago, the Citizens Review Board only has jurisdiction to hear appeals arising out of 5 specific policy violations. Neglect of duty is not one of those. And so if the duty to intervene continues to live underneath the neglect of duty policy, then we would ask for the CRB ordinance, as a matter of city ordinance, to be expanded so that category, neglect of duty, is one that the CRB has jurisdiction to review. I understand that the city manager and the police department are talking about ways to handle that, and they are not opposed to this. And it could live underneath the response to resistance policy or use of force, and then the city ordinance wouldn't have to be changed. But that's something that they are looking into. And so I have just handled, we're now into the third Roman numeral areas to strengthen citizens review board. Jurisdiction review, neglect, and duty, the third bullet point I've just addressed. I'll now talk about subpoena power. So I understand with respect to subpoena power that there's going to be another push from this legislative delegation to attempt to do that. And as I forecast before, the Citizens Review Board would like a city policy that would require officers, in addition to whether or not, and whether or not subpoena power is ever granted, to have a city policy that requires officers to at least appear, even if they're going to assert their Fifth Amendment rights, but to appear at CRB evidentiary hearings. These aren't the initial hearings. The initial hearings are the ones that are typically a couple hours and essentially serve as probable cause hearings to determine whether or not there's going to be a trial, an evidentiary fact-finding proceeding. And the subpoena issue only arises in the context of that latter type of proceeding that is more drawn out and there's actual live evidence given under oath. And so, and as I mentioned before, that is something that right now the police department opposes, is having that as a matter of city policy for officers to appear. And so, and then finally, as I mentioned and went over pretty extensively, this justified but potentially preventable disposition, that's something that the board feels very strongly about. And we met with Chief Jennings and Marcus last week and had a good discussion about this. Initially, so I think it's fair. Please, Chief, jump in if I get any of this wrong. But CMPD would say, well, they've already got a directive. It lives under the courtesy policy, and it's basically a provocation policy, and it says the officers will not taunt, verbally bait, or initiate needless or unnecessary physical contact with the subject. And they would prefer to just let that govern those situations and not add a new category of justified but potentially preventable underneath the response to resistance policy. And one justification for not doing that, the chief pointed out, well, that's kind of limitless. It could be used for, any number of situations from, did you answer the call for service? I mean, if you didn't answer the call for service, then you wouldn't have been there on the scene and it wouldn't have happened. I mean, that's the extreme, but there could be a lot of other things along the way that are just too attenuated to be causally linked to the shooting itself. And we gave some thought to that. And there are some, you could say that there has got to be some proximate causation. I'm sorry, I'm talking like a lawyer now, but some sort of causal connection between the thing that happened leading up to the shooting and the shooting itself. So, for the example I gave before about
Mr. Davis,
Road,
I've got a bunch of questions piling up, so I don't want to go too far down the path.
Ability to activate
Mr. Davis, can you hear me?
That's a policy violation. And is it reasonably, so proximate cause has got in the world of the law, this objective standard, just like the Graham v. Connors shooting standard I mentioned. Are you objectively in fear, imminent fear of your life or somebody else's life? Proximate cause, if there's a policy violation, is it reasonably foreseeable that a violation of that policy could escalate a situation and get you to a point where there's an imminent threat and then a justification for shooting?
Yeah, I think we understand your example, Mr. Davis, and I've got questions piling up. So I think you explained it very thoroughly, and I want to give Ms. Jamison a chance if she wants to add anything to that, but then I've got questions, and we've got a lot on our agenda. So, Ms. Jamison, did you want to add anything to that very thorough description of the outline there?
No, I think it was a very thorough description of the outline, so we'll take questions now. Thank you.
Ms. Wellington, your hand was up earlier. I don't know if that was a civil service or citizens review, but I'll give you the first crack at it if you had a citizens review question.
Sure. My original question was answered, but I do have two more. The first one being very, very briefly, if it is possible, and if not, we can skip it. I'd just like to understand, because one of the things we often hear from citizens is, had a a private citizen done this, they would have been charged with murder or manslaughter or whatever. Can you tell us very, very briefly what the difference is between the two? Because when people see these kinds of incidents, particularly when there's video, that is the first question that people ask, is how is it that an officer can, quote unquote, get away with murder versus a private citizen? And so I just want to understand a little bit more about how that is interpreted under the law.
Kerry, do you like to that brief answer?
Yes. I'll try. I'll do my best here. So, certainly in these cases where there is a fatal shooting, there is, in addition to an internal affairs investigation, there's a homicide investigation as well. And the homicide investigation would look at the shooting from the same standpoint, the same justifiable use of force, that Graham v. Connor Supreme Court precedent, as to was the officer who fired did they reasonably perceive an imminent threat? And that's the standard that's used both to judge whether or not a crime has been committed, and whether or not, in our context, the shooting was justified under CMPD policy. Does that answer your question?
Yes, I'm sure there'll probably be some follow-ups, but I just wanted to lay that foundational piece. The second thing is, can you restate the recommendation around expanding CRB's ability to look at neglect of duty cases?
Sure. So under the city ordinance that gives the CRB its powers, it lists the kinds of policy violations that the Citizens Review Board has jurisdiction to review, and those include the 5 that Stephanie mentioned. The duty to intervene is underneath the neglect of duty policy. The neglect of duty policy is not one in the city ordinance that confers jurisdiction on the CRB to hear. And so if there were to be a duty to intervene situation, and it's a subject of internal affairs investigation determination, citizens can't appeal that unless the city council changes the ordinance to give the board the jurisdiction to review those cases, unless the duty to intervene is moved under some policy that the CRB already has jurisdiction to review.
Okay, so thank you for that. So I'd like to move then to enable the CRB to hear neglect of duty violations or neglect of duty complaints, whether by including the duty to intervene sub-policy or moving the neglect of duty specific to a policy that's already covered. Mr. Chair.
Thank you, Ms. Watlington. So we have a motion on the floor from Ms. Watlington.
Second
And a
motion.
second from the Vice Chair, Mr. Mitchell. Do we have any discussion? I'm not sure. There was some feedback there. I didn't know if somebody was trying to speak or if we...
No, that was my mama.
Hey, Mama.
Chair says hello. He can hear you.
Tell her to come join us. I need to see where you get all these smarts and energy from.
Oh, yeah.
Discussion.
Hi, this is Jessica Battle, attorney with CMPD. I know Ms. Watlington just put a motion on the record. I just wanted to go back to her question about the differences in, if a civilian was charged, they will be charged with homicide, manslaughter, et cetera, versus if officers are charged, it's different. It truly is the same for officers. It's just a dual investigation. And so from the internal side, we are looking at the Graham factors. Was it reasonable? Was there a substantial violation of a known law and that sort of thing? When we look at the civil side of it, and internally, we're also looking at the Fourth Amendment side. Did our officers violate any policies? Was their use of force unreasonable from an internal perspective? But parallel to that, we are also, when I say we, I should say the SBI now would also be conducting a criminal investigation. So they're going to gather the physical evidence, do interviews, all those sorts of things. They put together an investigative packet and they give it to the DA's office to make the decision on whether or not the officer should be charged criminally. And so that process with the SBI is very similar to what would be done if a civilian were to shoot somebody. Because if it were a civilian, CMPD would investigate the homicide, collect all the physical evidence, do any interviews, and give the DA's office a packet about the homicide of a civilian. But from the CMPD perspective, the SBI does that gathering, gives the DA the packet to make the final decision. And so I just wanted to clarify that it's a similar criminal investigative, that we are investigating it criminally. It's just parallel to the civil side and the internal investigative side, which would, go a different route, if that makes sense.
Ms. Watlington, did you want to respond to that before we let anybody else weigh in on your motion? And I'll ask you, if you will, before we have committee discussion on the motion, if you'll briefly restate your motion, and then we'll let folks ask questions. And then, Ms. Watlington, I'll let you respond to that or restate your motion, and then Chief has asked to weigh in on it as well.
Sure. Thank you, Ms. Battle. That was exactly what I was looking for. I appreciate that. To restate my motion, then I move to update our ordinance to enable neglect of duty violations to be reviewed by the Citizens Review Board, whether by including the duty to intervene sub policy, or by moving neglect of duty specifically into a sub policy that's already covered.
Thank you, Chief.
So thank you, Mr. Chair. I think, and also just to be clear, we are okay with that as far as the review of duty to intervene. However, I would like to keep it where it is if you want to have the neglect of duty be reviewable by CRB, but not to move the duty to intervene.
So
I'm fine with that.
would you like to then restate your motion more specifically based on that?
Sure. I'll just move then to update our ordinance to enable neglect of duty violations to be reviewed by CRB.
Mr. Vice Chair, is your second stand? Yes. Ms. Ajmer or Ms. Johnson, did y'all have any questions on that specific motion before? I know that, Ms. Ajmer, you have a question related to Citizens Review Board, and I'll certainly give you the opportunity to ask that, but did you have anything specific to this motion?
Not specific to this motion.
Okay. And Ms. Johnson, if you had anything specific to this motion or questions?
No, I don't
Okay.
have any specific question.
Then I think, Mr. Vice Chair, did you have anything specific to this motion, or shall we move to a vote?
Move to a vote, Chairman.
All right, so,
Mr. Chair, it's Ed Driggs.
yes, sir, Mr. Driggs.
The motion should be for a recommendation to the full council. I don't think the committee has the authority on a standalone basis to impose this.
Yes, sir, that would be what we'd be doing, is sending this forward as a recommendation from the committee to the full council, the recommendation being the motion stated by Ms. Watlington. So, no, I have not somehow managed to grab more power for our committee, I assure you, Mr. Driggs. I would fully expect you to call me out on that if we tried. All right, so, Mr. Vice Chair.
Yes.
Ms. Watlington.
Yes.
Ms. Ajmera.
Yes.
Ms. Johnson.
Yes.
And I am a yes as well. So that will be a unanimous recommendation from the committee to move to the full council for consideration. Ms. Wellington, did you have additional questions you wanted to ask related to CRB, or is that
I'm
it for
okay.
now? Great, thank you.
That's it for me. Thank you.
I've got Mr. Mitchell followed by Ms. Ajmera.
Thank you, Mr. Chairman. And thank you for the presentation. I just have a couple of questions. I think we took care of important motion. So, Chief and City Manager, just share with us the kind of the pros and cons. Chief, I know you say you have a little opposition for. Let me make sure I got it right. City Manager could require accused officer to appear part of employment policy, and if that's not something CMPD can accept, is there a common ground or a soft spot where we can land? And
Sure. So Thank you, Councilmember Mitchell. As we've discussed with the chair of the Citizens Review Board and the lead attorney, we think the better part of this is everybody. And I think that